Your Honor, when we look at the scale, the scope of misdemeanor assaults, this is about as severe as it gets. We're talking about 15 baton strikes on a civilian by an officer at a train station in this county. So it only fits that with with a crime of this severity, the punishment should fit the crime. And because the punishment should fit the crime, we think the only thing that's appropriate for Mr. Warren is going to be jail time. And if he is to get probation, we think jail time should be a condition of that probation.
Your Honor, thank you for the opportunity to address the court. The court has set throughout the proceedings. The jury made its decision. Mr. Warren accepts the jury's verdict. In consideration, the court is also aware of evidence that was not presented to the jury, and then we feel that that also should be taken into consideration when assessing the appropriate punishment in this case. The state is asking for jail time, and they say that this is one of the most egregious assaults that could have happened. We could not disagree more. Mr. Warren, former Officer Warren, was acting in the course and scope as a law enforcement officer licensed in the state of Texas. He was acting in his capacity as a Metro police officer. He was with his partner there to patrol the rail platform and clear the platform so the patrons of Harris County can ride safe. He encountered Mr. Giles. Mr. Giles was not compliant the first time. We fast forward, and the court will recall the evidence. The court is very well aware of the evidence. The court has thoroughly considered the evidence. Mr. Warren was placed in a situation where, as a young officer, he was put in a fight or flight mode. He truly believed that he had to defend himself. And his testimony yesterday indicated the first few strikes in the second encounter were, in fact, justified. As I argued yesterday, and I'd like to argue again, I do not believe we were in this situation had Mr. Giles not fallen on that bench. Once he did, the strikes continued. What we saw was a continuous level of action. It wasn't broken until he was on the ground. As to the last two strikes, ultimately, that's up to the court to decide. But there was a level of justification built into this, and the jury did consider that as well. We do ask that the court also consider Mr. Warren and what he has done, where he comes from. Mr. Warren is currently enrolled at Sam Houston. He's been pursuing his degree since then, and is currently scheduled to graduate 1 year from today with a degree. He's no longer a law enforcement officer. He resigned from this position after the incident happened. His family was law enforcement officers. This was something that he aspired to do. As we heard testimony from his mother, Officer Warren is the type of person who's going to follow the instructions he was given. And I can express to the court, in my opinion, that I do believe he acted in accordance with what he was trained to do. Now, the jury has said otherwise, and as I previously mentioned, we accept that. But there is also great consideration in putting yourself in the shoes and thinking this was a fight or flight moment. This wasn't a moment made out of anger. We had no testimony to that. This wasn't a moment filled with hatred or frustration. This was a moment where a law enforcement officer was placed in a position to make a split-second decision. A decision that he never faced before. A decision that he had not experienced. And a decision that he hadn't been an officer long enough to know how to handle. Regardless of the training, as we all know, be it being a judge or being a lawyer, when we first start, we are subject to error, and we're subject to mistaken judgment. Errors in judgment and follies of the mind happen to those who are not experienced. If I could relive some of my moments as a young lawyer, I certainly would do things differently. And I can certainly understand that being placed in a position of putting your life on the line every single day can bring about a great stress. And a decision made in a split second could be right, could be wrong. And in this case, the jury has said that it was wrong. once again, to accept it. We ask for the court to consider either one, taking the amount of time that the process has taken into consideration. We are 3 years into the process. Mr. Warren was a jailer at one point. He has worked for the Harris County Sheriff's Office. He did go through the bonding process. We'd ask the court to consider that he has served his time and that the court levy a fine in addition to finding that he has served his time. Should the court not decide that that is the best course of action, we would ask the court to consider a term of probation where Mr. Warren can demonstrate through his actions that he is the upstanding man that he has been prior to the moment of the incident, after the moment of the incident, and carrying forward to today. If there was ever a case where the court's benevolence of a probationary period or consider the amount of time that he has been in this system would be appropriate, it would be this case. We've asked that the court take into serious consideration what Mr. Warren is doing. He's involved heavily with his church. He's had great support from his family. He has a family who's been in attendance the whole time. They've laughed with him, they've cried with him, they've shared his grief, they've shared his pain. They've shared the remorse. They've shared the regret. He has a support system. Mr. Warren has no flaws in his past, and he will have no flaws in his future. He's a dedicated, driven young man who, in spite of the media attention that this has received, in spite of the issues that this case has brought to light, has put his head in the sand and gone to school and sought to better himself in the only way he could. And now we sit here on the day of judgment, respecting the court's authority and requesting that the court take into consideration all of these things and assess a proper punishment, that being not jail time. We're of the position that jail time in a case like this sends the wrong message. It sends the wrong message to the law enforcement community. It sends the wrong message to the citizens, especially knowing what evidence is out there to be considered. The law enforcement community will receive a message from this, and it will be received not lightheartedly. And I implore the court to consider all of these things before it makes its judgment. We thank the court for its time and we respect the court's decision.
And so your client doesn't wish to say anything?
Your Honor, at this time, I've consulted with my client, and without going into any attorney-client matters, my client doesn't feel as though he is capable of expressing the emotions and the words that I have to the degree that there were. He does stand behind everything that I've said, but we consulted heavily, and that's what we're looking at.
All right, I'm ready. Mr. Warren, I also wear a uniform. I've been in the military for 18 years. May 9th was my 18th year. I plan on retiring from the military, and there's no greater privilege than wearing a uniform. I have my flag on my sleeve, Army on one side and my name on the other. Every time I put on that uniform, I walk a little bit different, I talk a little bit different. It's just a sense of pride. Sometimes when I'm leaving Fort Hood and they're taking the flag down, like I get excited. I said, I hope they take the flag down while I'm driving, because I get to stop my car in the middle of the road, get out, face the music, and render a salute. Like I actually love serving. I truly love serving, and I know it's an honor. And when you wear that Metro uniform with your name on one side, your badge on the other side, then you carry a lot of responsibility with you. You carry a lot of responsibility. One, you represent your family name, and that should mean something to you. On the other side, you carry the Metro badge, and that should mean something to you. When you have that uniform on, you represent all law enforcement across the country. Across the country. And you're only how old? 24?
Yes, sir.
24. In your lifetime, at least half of it, by the time you start watching the news, I don't know when it was, but at least from the time you were 12 on up, there's been 1,000,001 police brutality cases. And so in my mind, you should have the mindset, I want to make sure that I come from a community that distrusts the law enforcement. I want to show my community that law enforcement officers are good. I want to be that shining star. But yet, the actions on the video shows that you were just like a bully, a gangster with a uniform on. That extra kick, that last kick where he told you kick me and see what happens, that's stuff that I used to do in the hood, that I used to have to deal with. That's how you start a fight with somebody. Touch me one more time and see what happened. Cross this line, see what happened. Call my girl one more time, see what happened. That happened all through middle school, all through high school. And for you as an officer to engage in that type of conduct with somebody who's mentally ill, a mentally ill man, and for you to engage in that conduct and fall for the bait and then literally beat the mess out of him, you're an officer, you know what the proper charge is when you beat somebody with a deadly weapon. And you know you do not even belong in this court. And in your heart, you know that. And so, the punishment I want to give you, I'm not allowed to because it's not in my jurisdiction. But the punishment I'm going to give you, you're going to serve 2 years on probation. You're going to go into custody today. You're going to do 30 days. That's the maximum amount of time I can send you to jail. When you get out of jail, you're going to have a leg monitor that you're going to wear for 2 years, and you're going to be under a curfew. And if there was something else I could think to do to you, I would do it. There is no excuse for your behavior. The city of Houston could have burned down because you were outside playing with a mentally ill guy, kicking him, bullying him, or doing whatever you were doing that you called law enforcement that your own witnesses said was too much. Everybody who stepped on the stand with a badge said your behavior was out of line with training. We sent 18-year-olds, 17-year-olds to Afghanistan, Iraq, all over the country. By the time they're 21, they're a platoon sergeant. They're leading other soldiers. And they're out making life and death decisions. You had time to sit there, contemplate what you wanted to do, and you made the absolute wrong decision, and you have to be held accountable for it. And so, no guns, no drugs, no alcohol. And Walter, do a TRAS on him, and we'll see what goes from that. Can he take the bid course, or does he have to have a family violence? Can I tell him to have him take the bid course?
We can do.
Okay, and then you're gonna take the batters intervention program because you need help with your anger. Clearly, you have some anger issues because no rational person would be able to beat a person like that. If you beat a dog like that, if you were on the news beating a dog like that, that would have went viral. But because it was a mentally ill, homeless man, very little even attention was on this case. Maybe in Harris County, but nowhere else. But had that been a dog, that would have been a nationwide story. And so I hope you think about that when you're laying in your jail cell, when the guards and deputies yelling at you, treating you however you get treated, you need to go through that. And hopefully that will be ingrained in your mind the rest of your life. Yeah. I'm gonna stop before I say the wrong thing. But I'm embarrassed by your behavior. I'm embarrassed by your behavior, and you should be too. And the fact that you don't even want to stand up and accept any responsibility for yourself, say anything. Say anything. That's not a good sign. That's not a good sign. I'm sorry. I wish I could have handled it better. I was a rookie. I'd only been on the force for 11 months. This was the first volatile situation I'd ever been in. I wish I could go back and change the things that happened. I'm sorry. You can't even fix your mouth to say that. But that day out on the podium, you didn't have any problem. When it was between you and a mentally ill guy, you didn't have any problems expressing yourself then. So how can you be here today and you have problems? One day you will have kids. I don't know, maybe you're a man, maybe you'll have kids one day. And the lesson you want to teach them is accountability. Because one day you don't want them to end up in a courtroom like this. And the way that happens is you never hold your kids accountable. So from the next 2 years, I'm gonna make sure that you're accountable and that you follow the rules and the laws, and that everything I can do to help get you on the right track, I do it. If I could send you to WIMAC for the next 90 days and let you go out there, I do it. But they won't take you because you're a police officer, and it would be a safety hazard for you to be out there. But every possible option I consider for you. All right, so you can go to the back with the deputies, and you can start your probation. Good luck to you, sir.
Your Honor, respectfully on the record, and I understand Mr. Warren is going into custody for record preservation purposes. I've got a lot of some objections to any conditions we may feel unreasonable for appellate purposes. I would like to ask an appeal bond at this point.
Say it again.
I would like to request an appeal bond, and we can address that issue after I've lodged my objections. Your Honor, at this time, we'd object to the term of any jail as unreasonable. We'd object to the batter intervention prevention program, as that's normally reserved for family violence cases. We'd object to the length of the probation as unreasonable. We'd object to the terms that the court has laid down. The court had expressed that it would go beyond its authority, however, the court has stated in its authority. We would object to the reasonableness of the terms in order to preserve them for appeal. Now, Your Honor, at this point,
Hold on, let me respond, since we're on the record. Your own witness testimony that you brought out in the trial, your cop that you put up, you asked the question, which one is more lethal, a taser or an aspartame? And he said both of them are lethal. And then when you combine that with assault, all by your own testimony, and with the conviction by the jury, them ruling on the facts, this should have been an ag assault case in 2 to 20.
Your Honor, respectfully, this went to the grand jury.
I know it went to the grand jury, but by you proving up deadly weapon, the jury proving up the assault, this should have been an ag assault, right? And so, me giving him a 2-year probation, one of the most heinous attacks I've ever seen in my court. I don't think this is too far. I don't think this is too far. This is just probation. He's going home. But he has to do his time. And so have your objections on the record, and if the appellate court turns down and does something different, then we'll go that way. But right now, this is what's happening.
I understand, Your Honor. I would like to lodge the objections again as to the conditions that are unreasonable in this case. Furthermore, at this time, I'm assuming that my objections are overruled.
Correct.
We would request an appellate bond, Your Honor.
All right, give me a second to determine what's the proper bond.
Yes, sir.
All right. Anything else?
Nothing from the second.
All right. Yeah, let's take a 5-minute break.
Property out too.